Defamation is defined as a false information spread with the intent of injuring someone's reputation. Now, this topic might be a little difficult to understand, so let's find a way to make this more interesting.
Welcome to the year 1960. It's September 24th. Mr. Krishnaraj sits down to read his newspaper. And look at that! This week's issue of Blitz is out. Mr. Krishnaraj reads in horror as he sees statements about an alleged involvement in unethical methods to accumulate his wealth. But this was not his first time dealing with this journalist. In fact, Mr. Rustum had written an article about Mr. Krishnaraj and his business, House of Takarse, and their alleged involvement in the black market in the year 1947. These statements did not hold water, and Mr. Rustum was demanded to issue an apology. After an unsatisfactory attempt at clearing up the confusion, Krishnaraj decides to take him to court, where Mr. Rustum surrenders, but only because he wants to go abroad and didn't really want this whole case to slow him down.
But now, our dear journalist doubles back in the year 1960 with a more malicious attempt to ruin Mr. Krishnaraj's reputation. Another trip back to court, Mr. Rustum. The final verdict was a compensation of 1,50,000 instead of 3 lakh that Mr. Krishnaraj was hoping for. All rise for the Honorable Judge Mr. Palekar for the further proceeding.
Welcome to the year 1960. We are here in the courtroom of the case of plaintiff Mr. Krishnaraj M.D. Thackeray, a businessman from Mumbai, was defamed by Mr. Rustum K. Karagia through his article in English Weekly Blitz published on 24th September 1960. The plaintiff complaint is that the defendant has falsely accused him for accumulating money in a malicious way. Is the prosecution ready?
Yes, my lord.
Is the defender ready?
Yes, my lord.
Are the lawyers ready?
Yes, my lord.
Alright. Now let the prosecution may start their opening statement.
Well, I think as a journalist, I have the right to speak and express my opinions and put out the facts that are true. And it is legitimate interest of people to know about it as he is a prominent businessman.
My lord, may I have the permission to start the further proceeding?
Permission granted.
Thank you. Supporting my client's argument, I would like to state whatever my client Mr. Rustum Karagia has said is quite obvious, because my client has noted Mr. Krishnaraj, who is a businessman, has been involved in some unlawful activities. He imported yarn from the abroad since long back and without even taking government's consent. Okay, so that is something in the public sphere because he holds the position in the authority, and that is also the public legitimate interest to know about it. So yeah, I would like to plead for the qualified privilege.
I'm a prominent businessman and a reputed director of the Bank of India. I'm well known in this industry with regards to import of cotton from the company under my name. I'm not responsible for the destination of these bales and cannot keep track of every order.
Your Honor, my client is a reputed businessman, as he had just stated. The article that Mr. Rustum has published was not only defamatory, but it was injurious to my client's business, his reputation and his credibility. Moreover, I would request the denial of the plea of qualified privilege, as one cannot create an occasion to practice qualified privilege, as you need an obligation to justify it. Thank you.
After listening to both the parties, now the judgment is in the favor of Mr. Krishnaraj. The plea of qualified privilege is denied.
Congratulations. Mr. Krishnaraj had successfully built the vast empire involving his wife, friends and close relatives with the involvement of unlawful and questionable activities. These objects of the article submitted by Mr. Chari depicts that the subject matter of the article was in the great public interest. The public are vitally interested in being assured that great concentration of wealth, which is discouraged by clause B and C, Article 39 of the Constitution, does not take place at all. And if it does, either because of the government inaction or because of deliberate violation of the law on the part of any business organization. There is no particular law for the defamation. According to Section 19A, 500 to 502. It totally depends on the degree of the defamation. In this case, we see that Mr. Rustum says that this story gave his newspaper a privileged occasion. We also see in court that this plea was dismissed. Now, what is a privileged occasion? It is described as, and I quote, an occasion giving rise to a duty on the part of the newspaper to address a communication to its readers. Now, the plea of qualified privilege was dismissed because there was no obligation towards Mr. Rustum to publish this article. Therefore, there was no justification. In simple words, no one really asked Mr. Rustum to write this article, so he had no justification. One cannot simply create a privileged occasion. Mr. Mistry, Krishnaraj's lawyer, said that he could prove that this article was a malicious attempt at ruining Mr. Krishnaraj's reputation and therefore destroying his credibility and business. He did this in 3 ways. 1. Mr. Rustum himself did not believe the truth in these articles. 2. He was more focused on conveying his dislike through his libel and covering it up with privileged occasion. 3. His headlines were also extremely blunt and had a sense of finality, which in reality he didn't really have yet. Now, as a journalist, we can say that he has the right to write the content he thinks is in the interest of the public. Mr. Krishnaraj does combat the arguments Mr. Rustum made against him. But as journalists, it is our job to provide an unbiased article and let the readers decide. It is not our job to condition them to have some sort of view. The article was proven to be written with malicious intent and not for the public interest, and therefore cannot be protected under the law.
Technology keeps developing so much that it is taking us towards the digital world each day. As we all know that the future is digital, and so it will require us to be in a set of rules and guidelines. Defamation is a criminal offence as well as a civil wrongdoing. Therefore, civil or criminal procedure is to be followed. Now, the punishment for defamation. The section 500 to 502 of Indian Penal Code states that whosoever defames another shall be punished with simple imprisonment or for a term which may be extended for 2 years, or with fine or with both. We need the law of defamation so that nobody can use their freedom of expression as to injure another's reputation or to indulge in what may be called as an character assassination.
We know that we have shifted to digital now, and most of our work and activities are done digitally. This digital media has the power to spread any news stories very quickly, and it looks like a free will, which means it has provided us the power to interact, form our opinion, and comment on any news stories or publications that are done digitally. Due to this power, many people thought that they are allowed to do anything on digital, and most of the time tries to defame someone and succeed. So, the question arises now that why do we need to discuss defamation in digital media? Because the news spread like fire when it comes to digital media in comparison to traditional media. Previously, the news take time to spread, because not everyone watches the same news channel or read the same newspaper. And some are also not interested in watching news or reading the news. But now, due to in digital media, the news will automatically pop up on your devices and it will be reshared to you by someone because of the internet. So it has become easier to defame a person digitally, which can cause harm to person's reputation, self-respect, and career also. So the laws, rules, and guidelines for functioning individuals, the right of expression digitally should be monitored and implemented strictly. It is very important to work under the guidelines issued by the government for working digitally. For example, we have seen in the case study of industrialist Krishnaraj MD Thakurse and the journalist Rustum K. Karnajia. We saw that how plaintiff claimed defendant for defaming him after defendant published article against him in 1947, and how the court proceeding went and what was the judgment. We saw that in traditional time also it was not difficult to defame someone, and now it is digital. So defaming someone can be done just in few minutes. So it is very important to discuss in digital media, and whosoever defames someone will be punished and the procedure will be same again, because it comes under the criminal law. In India, most of the digital publication of news articles are done by DGPub and DNPA, and they all work under certain guidelines. So if someone is defamed by the publication of any news article digitally, then the editor, publisher, journalist, and the news organization all will be liable for it and can be brought to the court. It is true that press or media is free, but certain reasonable restrictions are imposed by the Constitution of India and also by digital association, under which defamation is a very serious topic.
In this case, we can see that Mr. Rustum has written an article in the hopes of exposing Mr. Krishnaraj. He had already made an attempt in 1947, but because of this, the attempt in the year 1960 was more believable as the case of malice rather than the public interest. We see there's a fine line between freedom of speech and defamation. The way we frame our sentences is imperative. We must make sure that the content we write is well researched and is written in the way that conveys information to the public but not the verdict.